Now, whether you're an investor, a startup, a branded business, or maybe you're just selling someone else's branded products, or maybe you're promoting your own brand, I don't know. It's whatever the circumstance, it is imperative that you take the necessary step to safeguard your intellectual property. Now, intellectual property covers and protects more than just ideas and concepts. It shields genuine business assets that are probably pretty integral to your business and its long-term success. Now, intellectual property can consist of many different things. You've probably heard terms such as patents, trademark, copyright, or even the term registered design. We're going to get to the bottom of what some of these things actually mean in plain language, not legal speak. And it will be helpful, I think, if you understand what these things mean, the protection of them will become a little bit more easier to understand as well. Now, these things tend to differentiate your business from your competitors, which is why you stand to suffer significant losses if these things, these patents, trademarks, copyright, what have you, are used without your permission. Now, any company, it does not matter the size, is at risk of having ideas, products and services, processes, or even brands infringed upon. And this can happen by somebody down the street, or even by a party that's completely on the other side of the world, making protection that much more important. It's more important than ever, really, for the survival of your business, which is why I'm really excited to have Brian Goldberg on the program today. Now, Brian, like me, is based in Melbourne, and he's a qualified trademark attorney. He has significant experience protecting brands, logos, slogans, and other types of intellectual property, not just here in Australia, but also abroad in every and all international markets. So welcome to the program today. I'm really excited to speak with you, Brian.
Thank you for having me, and it's a very kind introduction.
I'm guessing that most of the people that are listening to this right now, they're small business owners, so they're not necessarily qualified attorneys like yourself and myself. So let's just start right at the very beginning and talk about some basic definitions so that everybody understands that there is, in fact, a difference between something like copyright and trademark. Why don't you take us to the very beginning and we'll go through that together?
Sure, that's a good idea, good place to start. So intellectual property is quite a big word and it means a lot of things. But really, from my perspective, there's specific laws under it. 1 is trademark, 2 is copyright, 3 is patent, 4 is design. And I'll touch on the elements of each of these. So a trademark is the brand name, logo or slogan that represents either the company or the product. But there's no automatic rights. You have to file your trademark. In Australia, we're lucky that there are some residual rights for using it. But in most countries, first to file means first to own the brand. And so it's something you definitely have to look into early on in the piece. The next is copyright. And with copyright, it's actually an automatic right that the creator obtains once they've created work. And work is defined as any literature, any written words, marketing material, dramatic, musical, or artistic works. And so whoever actually creates it owns it. So if you're writing a blog or if you're writing a marketing material, taking photos, the person that clicks the button is the one that owns it. And then we work that through. The third intellectual property right being patent, it is a lot more complex and it relates to an invention. So you need to have an inventive step. So it's a functional product or service or method of manufacture, but it's inventive to what exists before. And with this one, it has to be new, so no one must know about it. It can't have been shown to the market. And you do have to file your patent rights. And that gets quite complex. So right at the front, I'll say best to use a patent attorney if you have something inventive. And the fourth intellectual property right is called design or design registration. And that's for the shape or form of a product. So if you've got a new coffee cup or a new vase. The shape, if it's new and distinctive, can be registered as a design. And that will prevent others from using the exact same shape that you're using in the marketplace. So other than copyright, trademarks, patents and designs need to be filed, and designs and patents need to be filed when they're new and not have shown to the public. So I hope that just gives a summary of the 4 intellectual property types that we refer to.
I think that's an excellent summary. And I think it's really important to differentiate that, as you said, copyright is created automatically. And I think a lot of people presume that that is the case with some of this other stuff, and it isn't. So from the perspective of a typical small business owner, the thing that I think is going to come up most in the operation of a small business is probably the issues of copyright or trademark. So I kind of want to start here, if that's okay with you.
Sure.
In the context of small business, do you find that most businesses are focusing solely on the protection of these things in a very local sense, or they are broad enough to, foresee that international protection may also be needed? What's your personal experience with what's really happening on the ground?
That's a really good question, and boy, have things changed in the last year. So I've worked with a lot of startups and small businesses now over 15 years, and definitely it was locally based. We'll start small. The perceived costs were just a negative barrier. They didn't even look into going broader because it would take a lot of export effort in the past to do so. So they just thought, okay, well, let's just look at the local Australian market. And even in Australia, it's not compulsory to file your rights. And it was a passive view. Well, the digital world's caught up with us. Once you're online, you're exposed globally, and the savvy entrepreneurs starting small businesses are thinking global right now from the start because they're online, they're social, they're trying to win the Google search game, they've got their Facebook page. So those elements have really inspired the small businesses to think, oh, I live here, but my product, service, offering, it could be anywhere now. So things have changed.
What are the typical products and services or ideas that are most at risk for small business owners to be taken by someone else?
Well, I'll use those reference to time frame. Probably before the real digital world, we used to get everything made overseas. And when we got things made in China and other places, we had already exposed ourselves completely to losing any inventive or materials or patents or trademarks because we've had to expose them to international manufacturers and agents who are pretty savvy, are very savvy. So that used to cause a big risk. And it still does. It still does. Now, a big risk is everything we do is online and it's exposed globally, not just to the manufacturer. And I think we need to take a breath when you start the business and make sure that everything's set up in case an international opportunity comes, let alone an international copier. And so making sure that you're set up in your foundation, call it IP foundation or just business foundation, is in place. And I don't think costs are an excuse or a barrier anymore because it's a global marketplace and the same rules go across every country and every product and service.
So if you were advising a small business that perhaps is starting out, what would you say are the necessary steps they need to take to get their IP foundation in place correctly from the start?
That's a good question. And we'll start on the positive side and then look into what they have to do to try to avoid conflict. So initially, we want to look at your brand. Is your brand available, and is it potentially trademarkable? And is the brand important to you? And if it is, then we need to do some research on the availability in Australia and its distinctiveness. And now there's online search tools where we can look at your potential key markets globally and see if things go well, is that brand available internationally? So definitely looking at the branding and trademark databases for the main countries is important. Secondly, if you are using third parties such as freelancers and outsourced marketing departments, then you have to ensure that the creations they do, that being the copyright works, photos, marketing material, literature, that you will ultimately own it, because the default position is that the creator owns it unless proven otherwise, and the proven otherwise is in your agreement with them, which needs to be sorted out before you engage them. And that catches a lot of small businesses off guards, because you think, I told them to draw that logo and they're claiming they own it. Unfortunately, from an intellectual property perspective, they do own that copyright unless it's in the agreement that upon payment it's assigned to you. So there are catches in the copyright ownership that I think small businesses initially, if you take a shortcut, they'll do that. And as you mentioned, I shouldn't laugh, but these days with encrypted technology, cutting and pasting images and thinking, how will they know I've got it, doesn't work. So I'm assuming that most small businesses will go down that path at this stage. But engaging freelancers and others, you need to know your rights. Then in terms of, if you do have a product and you think your product is inventive, well, you should look into, is it potentially patentable, or does it need a design registration? Because even though it's an upfront cost at the start, once you've exposed it to the market, you can't then go back and say, now I want it protected because it's popular. You have to make that decision beforehand. And I agree there are costs, but making an informed decision by having it looked at before you go to market at least gives you the opportunity to decide, do you want to protect it with a patent and design point of view? In addition to that, as I mentioned, the world's progressed into social media and e-commerce. E-commerce, I was lucky enough to be on a international trademark committee with the head Amazon person 6 years ago, and boy, did I get excited about Amazon back then. I've been promoting them, and only in the last few months have the popularity started to become enthusiastic in Australia. But on Amazon, to avoid counterfeit, unless you have a registered trademark in the jurisdiction you are selling, you can't sell on Amazon, the biggest global market in the world. So getting your trademark filed and registered will take you 7 months at best, and that's the day you can start selling on Amazon. So there's a lot of things you need to consider to align your intellectual property and your business plans. And hopefully that then allows you the foundation to say, I'm ready for the opportunities. I'm ready to be digital, social, Google search, Amazon. And importantly, I'm ready to invest in this brand or product or service.
Because if somebody invests a lot of money to launch a brand and then 6 months down the track finds out that perhaps there's an issue, there's a bit of risk here, maybe somebody else is using that brand, something's going to happen, right? They're going to need to go see a lawyer. They're probably going to need to relaunch their brand. It could be quite costly, couldn't it?
That's a really good point. Yes. Unfortunately, there are different ways to think of the cost, but I regard two important factors. One is the actual cost of rebranding. You might need to engage a branding person. You might need to file new trademarks. You'll need new material, new social media. And there's a cost. In the old days, it was, we'll throw out these 100,000 brochures and magazines, but now it's digital, so it's not extreme. But to me, the real cost is the intangible value that the brand built, the reputation, the consumers, customers that know your brand and what it means to change their mind. That's an expensive investment. That's not easy, and you end up losing a lot of goodwill and unfortunately a lot of customers in the being forced to change a brand name. So,
cost, right? Let's say you've got the cost of rebranding and you've lost some intangible value. What about the legal costs of having to defend an action by the actual owner of that property?
Well, that's right. And if you're going to be forced to change your name, then maybe the legal expenses are moderate, and of course there'll be costs, but you're really begging that the other part, that it was innocent and the other party won't claim damages from you. And so you're just really...
Under what circumstances could somebody be exposed to significant damages, maybe exemplary or aggravated damages, Brian?
So if you are infringing someone's trademark and you've sold a lot of and made money, well, then you're exposed to damages, because they're saying that not only did people buy yours under where it was our brand, but your products, but they also took away from us potential customers. So it's not just you made $1,000, we're owed that. It's you made $1,000 plus we lost customers because of this infringement. So it is very expensive. It can be. So the more popular you are and the more success you've had, unfortunately, that will come back and bite you if you haven't set up correctly at the start.
Yeah, fair enough. So what happens if somebody is operating a business and they find out that they've got a brand that they're using and maybe they're safe here in Australia? Maybe they have the right to use it. But then, like, the UGG boots is like the classic example, right? There's the American company that's filed for the use of UGG in America, and now they're suing the Australian person for using it because they've got the rights in America. And maybe the guy here sold a couple, 7 pairs or whatever it was to customers in America. What about that?
Now, that is the big question. And international trademarks, I've been fortunate to have travelled over 15 years and been to a lot of countries and all the conferences, and it's a huge issue. So there are 2 ways to approach it. If you're a small company but you're starting, then I suggest you do look globally and see if you can find a brand that could be potentially protected in your major target markets. And at this stage, I won't stereotype, but USA is popular, UK is popular now, Europe's popular, South Korea is popular, and Japan. So they're the main markets where Australian products and services seem to be, they are statistically the major markets. So you'd want to look in those markets to see if your brand or your new brand could be protected in those markets from the onset. There is a 6-month window of opportunity. If you filed it in Australia, there's a 6-month period where you can wait before filing internationally, or you could then file internationally at a later stage. But I think looking broadly to start with would be a huge advantage. Unfortunately, if you've established a brand in Australia and then want to take it overseas and find it's already taken, local jurisdiction wins, so you're going to have to change your brand internationally. And that becomes a real hassle and headache to have a local brand, an international brand, different, whereas social media is all the same. And so it's not ideal. And I would then consider rebranding at that stage as well to align with the international needs. So,
think that the proliferation of social media has kind of muddied the waters of the borders a little bit? Because let's just say that you've got a brand here in Australia and you have a trademark and it's very, very successful, meaning it's known quite well in some of these other markets. It could make it difficult for people who are in those markets to then get a trademark for that thing, even though you don't have one over there, because your brand is so prolific that it's already reached those markets.
That's right. I've had 3 different matters with small businesses, 2 small fashion clients here, one in Melbourne, one in Sydney. They've got a letter, one from Italy and one from France, saying you're infringing that's our hashtag in Instagram, and they're saying, well, no, that's ours. And fortunately, we had trademarks, so we didn't need to be removed from Instagram when I showed the trademark certificate. But had we not had the trademarks, there was no conflict, and they were all random coincidences. But yes, the fashion people in Italy and France both got annoyed that someone's copied their brands, even though we didn't copy, and it was just a coincidence. But yes, social media exposes you. And like you said, getting the foundation right is a lot better than having your social media pulled down, especially if you've got a big audience, especially if that's your revenue source.
So what do you recommend if you've got potentially a small business here that has a trademark and they notice that someone else is using it? What do you recommend that they do? What are the initial steps that they can take?
I used to be a bit more relaxed, but now I've got a simple philosophy: nip it on the bud. I've seen a few circumstances, too many, where it's been let go because we couldn't be bothered and it must cost more to enforce and etc. And then suddenly that opponent with an allegedly infringing brand starts dominating the market. So by nip it in the bud, I think it's important. The first step is you send a letter of notification and you somewhat amicably just outline your rights. And a lot of other businesses and even a lot of corporates then respect that and go, okay, we see you've got rights and we see we're close. Can we come up with a negotiated position, or we will change? And that happens. It happens a lot. And I think it's quite fine to send someone a letter of notification or to receive it and to know there's going to be an issue and to know early on and either deal with it in a friendly or adversarial manner. So that's okay.
What percentage of disputes get solved at that first stage, Brian?
In the last 2 weeks, I've had 4, if you took an average, and 3 got resolved. Because a lot of people ultimately, in Australia, every country is different, but in Australia, people want their own brand and reputation. They see, hey, so the big ones are definitely social media and Google search. And Google search is at the moment the number one instigator to motivate people to take infringement action, because someone's copying their brand in the keywords or getting close and they're coming up under Google search, which is taking away business from the legitimate brand owner. So that's the most annoying aspect at the moment. And that causes, I think, some aggression from the legitimate owner saying, I should be getting all the Google search traffic. They've just copied my name somehow.
Yeah, look, and I think that's a really important point, right? If someone owns a trademark to a brand, and it could be anything, that person is entitled to the Google search results for that brand.
And that's right.
There's been a number of cases, hasn't there, where some pretty large companies, I think, got into disputes with Google because they were bidding up the search terms for certain things that were trademarked by these smaller businesses, and they were getting the traffic.
That's exactly right. So they thought they could advertise and mention the other company's name somehow, and overcome the Google search, which is what the other company was trying to do. So for small businesses, if we're in name creation, I think it's a valid point, so I'll mention it now. The key to winning on Google search and social media and branding and trademark is to come up with something distinctive, because then it's a lot more obvious to everyone that you're being copied, and then it's a lot more obvious to customers that that's your brand, you're the original person in that brand. And I say that because in Google search, I had a few sports technology companies, and one of them had a somewhat generic name, but we did manage to get the trademark through. However, their competitor used that phrase in a descriptive way that wasn't a brand infringement, but it managed to overtake them on Google search and annoy the hell out of them. And we fought, but unfortunately, if the phrase is descriptive, then Google and others aren't going to react. So having a distinctive brand name is a really good feature, especially moving forward in this potentially global marketplace.
So how can someone know whether it's distinctive or not? Aside from, obviously you're going to want people to contact you or contact somebody who is a trademark attorney to help them through the basic process. But what could somebody just do as a layperson to do a quick check and find out if it is distinctive? What are the easy steps?
I'll define distinctive first, and then I work with a lot of marketers, and I love them all, but I'll share a story on where the business owner has to think for themselves. So there's a spectrum between totally descriptive and totally distinctive. So totally descriptive is if you're selling soft pillows and you call your company Soft Pillows, well, every other company selling pillows that are a bit soft can call themselves Soft Pillows. So you're not going to get any distinctive brand value there. On the other hand, I happen to have been market research. One company that sells product in every single country around the world spent, I think it was $5 million, this is 20 years ago, on market research, and asked every country, did a linguistics check in every single country to make sure they wanted the most distinctive trademark of all time so no one could ever copy. And they did, and they got it. It was a petrol company, and they rebranded to Exxon, EXXON, had no meaning in any country whatsoever, never been spelt before, distinctive, and that's the extreme of distinctive, is EXXON was a completely made-up word that meant nothing in any language, any country. Now, no one can go to that extreme, but where I come back to my great friends, the marketers and the brand creators, is if you want to spell out what your product does, so softer pillows, and you think you can brand it, unfortunately, marketers love it because it's already telling the customers what you've got, but it's not that distinctive brand. We need to move down the spectrum to a more distinctive branding aspect. I won't mention the names, but there are companies that get it, and the best brands, so this is Brian's definition of best brand creation, is when the brand connotates the value proposition of what you're putting forward. So instead of saying soft pillows, if you can come up with a connotation of the value proposition of the pillow, then that's the winning brand name rather than soft pillow. I won't give it to you. You come up with your own version. But we're not here for brand creation, but that will give you distinctiveness. And then you go capture the trademark, the social media tags, the domain name, and others. And the marketers are somewhat happy because the customers end up understanding what you're all about.
In most cases, a simple Google search or a simple look on Instagram or Twitter or Facebook is going to give you a pretty good idea whether that proposed distinctive term is in use already or not, correct?
Yes, for the goods and services that you're offering. Yes, so trademarks is actually distinctive. You can have, unless you're famous, a brand can exist for something else, and you can have it for yours if the products aren't related. So yes,
That's a really good point, because I don't know if I ever told you this story, Brian, but I recently wrote a book called Pricing Value, and I was thinking about trademarking it. But when I went to the IP Australia and I put through the documentation, there was a company in Japan that had a trademark that was really, really similar. But because it was a Japanese department store, they had literally trademarked almost every class of goods and services that you could imagine. I thought it was fascinating that, this department store in Japan had trademarked something in relation to their department store, but potentially my book, might have been kind of caught by that, even though it wasn't the exact same phrasing at all, but because they had literally, used every class of goods and services that you could imagine.
well, on that, I'm not surprised, and I'll share some international perspective, even though we're talking small business and so on. I've been to many trade shows, and I think my last one was just before we went away to travel in the US predominantly, but I've been to Europe and others. And in the US, I went to the biggest car show in the world. Not car show, car accessory. It's the biggest in the world, called SEMA, and with one of my clients who had a product that we sell. There must have been 10,000 stands, huge, big, that means 10,000 slogans, 10,000 logos, 10,000 brands. Not one would ever exhibit in the US unless they had a registered trademark. The value of branding is enormous. When they have a trademark, that's when you walk into their offices, that's the first thing you see. So the value internationally is a lot higher than we do in Australia. In Australia, it's, oh yeah, I should do it, I shouldn't. Whereas I come from hearing the US companies, and they are proud that they own that brand. They're investing in that brand once they own it, and that's what their whole moral in life is about, building that brand. And so I see here we're a bit blasé, so I prefer, I guess I'm biased, but I prefer to think about, okay, well, it is of value. It is what you represent to the marketplace. So get it right, take your time, and then build it up and respect it and grow it and nurture it, because that's where the value lies for all these American companies. So thanks for allowing me to make that point, but I am passionate about making sure that a brand is of value to your company, potentially the most important asset in your company. So getting it right is important.
How can small businesses know what they should be putting or setting aside to actually defend this stuff? Because it's one thing to have the trademark, and it's another thing to defend it, isn't it?
It is. So the first thing is you can't defend it unless you have it. So I'll say let's stick to the foundation. In terms of defending it, I like mediation. I like working things out. A lot of companies like settling. In fact, the larger the corporate, the more reasonable potentially they are, even though they've got the main play. They understand the system and they understand rights. So don't be scared off when a large corporate approaches. They're better to deal with from my perspective. So it's case by case on are you being copied or are you copying or what's happening. But unless you've got the right, and in fact at the moment another trend in Australia is a lot of people are getting seed investment and even bank loans, and a lot of people then want to grow their international business by licensing, and ultimately what they license is the brand name. Investors will obviously want you to own the brand name, so that's an asset in the company. So from that perspective as well, it's really important because a lot of investors really run away if you don't get your foundation right from the start.
Well, I know for ourselves, if like just in my own personal experience, having had a software company, often going out and talking to investors, talking to big corporates who wanted to license the technology. One of the very first questions they asked me is, do you have patents pending? And I spent a lot of time going through the various jurisdictions we had applied in, what stages we were at, what was, novel and inventive about our approach, all that sort of stuff, right? So it wasn't just the potential investors who were interested. It was also the bigger commercial partners.
And that's you are exactly right. And I know it's frustrating. I know it can be costly. And I know it's time consuming when you're trying to start a business. But my first experience, 22 years ago, we won't say 25. I won't round it up. Was I had a sports technology and footwear, and I went to the US, got a meeting with Nike, and as you walk in, they say, we're going to try to copy your IP. So do you have anything? And you either say yes or no. Luckily, we had US patent protection on it, and the meeting went ahead. If we didn't have it, there was no meeting. So once again, taking yourself seriously and giving it the opportunity, it is an expensive and time-consuming process, but if you're playing in the international market, even though you're small, small is an interesting word. It's do you want to stay small is my definition. And being in Melbourne or Australia, that's not a limitation anymore. So it's really where do you want to go, and if it's anywhere overseas or even in Australia with social media and business, getting the IP foundation right from the start, I still think there's no other choice at this stage, and unfortunately, it just takes a bit of time and effort, and potentially funding. But it's not unreasonable these days the amount of money to spend. For example, do you want examples of budgets?
Yeah, I think.
Yeah. Okay. So I'll start with the good news. Copyright's free. That's as good as you get.
CMA letter.
But you need to articulate what the copyright works are. So whether it's a photo or the marketing material or the literature or musical work. So you want to clearly put it into a document or audio file or photo gallery and date it and do everything correctly so it's clear that you own it and the date. The next is trademark. Trademark costs about $900 per class in Australia to get someone like myself, an attorney, to do it, or it can cost probably half of that if you went directly. And IP Australia is quite helpful, quite reasonable, and you could luck in and get it right. Then if you go internationally with trademarks, there's two systems. One system is we go directly to a country such as the US, and it'll probably cost $5,000 all up to file, register, and provide evidence. Alternatively, if you pick a few countries, US, Europe, UK, it's part of an international filing system. And once again, for that $5,000 for the same amount, you might get all those countries, but it's just in the filing system, so you've got no one representing you. But it is more cost effective. So that's a start for trademarking. Design in Australia is probably about $1,000 per design or less through IP Australia directly. And that's protecting the shape. And then we get to patents. And patents, once again, you can do it yourself, and the filing is about $500, but it's another world, and absolutely it's between.
Even as a fully qualified lawyer, I benefited immensely from having a patent attorney doing all that stuff because it was highly complex. And then, I felt like we were repeating ourselves over and over again, but that's, there is quite a system and process to applying for these things.
You're exactly right. And as a trademark attorney, and I've got science degrees and I used to do patent searches, I would only use a patent attorney. It's a whole language, it's a whole game, and it's a global game. You're not writing a little patent for local market. It's a global patent.
My experience is you're probably looking between 5 and 10K all up just for Australia by the time you do.
And that's for filing, and then in 12 months to extend it or to actually complete it and get it examined. Patents become expensive because the presumption from the patent office is that you're selling your patented item and you're making money. So it becomes more expensive. Renewal fees regularly and registration. So it is an expense, but it might be your little business feature. It's worth looking into if you've got something inventive. But I will say the patent is the aspect that can be expensive. If it's just a nice thing to have, then I'd think twice. If it's essential, then protect it and make a good business of it.
I think intellectual property is one of those areas that is so important and so extensive that we could probably literally speak about 4 hours on it and never repeat a simple nuance or a simple topic that we had touched on before. But if people want to get in touch with you and they want to know a little bit more about how can they go about protecting what they have, what's the best way, or maybe they need help to defend what they have, I don't know, but what's the best way for them to get in touch with you, Brian?
Thanks, Rhonda. Yeah, my email's good and it'll be on it. My phone number I'll give as well. I'm always happy to have a complimentary look at the situation and a look at the brand, because I only want to do something if there's a chance of success. So I'm always happy to help and look at things. It's a complex world. I've got no problem if they want to self-file and everything else. The most important for me is that the business gets an opportunity to capture its value proposition, whether it's brand, copyright or trademark or design or patent, and they do it correctly at the start, because unfortunately there's no second chance with a lot of these rights.
Look, and these rights are integral. I mean, I guess I'm in a little bit of a unique position because I've had an opportunity to pretty much avail myself of almost every last one of these aspects that we are talking about today. And I can say this, every dollar that I've invested protecting my intellectual property has been money well spent. And similarly, every single dollar that I am investing or have invested to defend those rights, which I'm even currently doing right now vigorously, has been money well spent. So I recommend that people take this really seriously, that it's not something that we just brush under the carpet and think, oh, it won't happen to me. If somebody else out there is potentially using your brand, you need to know what the implications of that are. If you are potentially using someone else's brand, maybe unknowingly, unwittingly, you need to know what the implications are of that for you. And I highly recommend that you make today the day that you find out what those answers are. So thank you so much. This has been super valuable. Even as much experience as I have on this, I learned stuff today, and I wrote down some really great tips that I'm definitely going to go on and share with some of my clients. So thank you so much.
My pleasure. Thank you very much. You're doing a great job and really appreciate and you do have a deep understanding in this area, and it was great to discuss it with you. Thank you.
Pleasure. Thank you so very much.